for anybody who's seen A Time to Kill with, Jake Brigance in his closing argument, right? And it's the story of this young Black girl who is beaten and raped and dragged and left for dead. And he then asked these jurors, almost all white, to now imagine she's white. And we did something similar where we showed the Loggervales in the car, and then we transitioned it to a car full of 3 white women. Do you think that this thing goes down the same way if these are the people? And there just wasn't, at that point, at least in the trial, I don't think there was any way for any juror to reasonably say, yeah, the cops would have behaved the same way. And so that got us to the point of, isn't this crazy that this sort of thing is still going on just because of the color of somebody's skin?
Howdy, and welcome to the show. I'm really excited about today's program. We're doing something a little bit different. What we're going to be doing today is one of the first of what we're going to call our after-action reviews. And in that, we're going to be taking a look at a verdict or other result, have the people involved, and kind of parse through how they got what they got. In this situation, we're going to be talking about the Loggervale case, which was a notable civil rights case. We're going to be speaking with Joseph May, Brian Gearinger, and Craig Peters, the lawyers who were involved in this outstanding verdict. They were also able to preserve when it went all the way through appeal. We've had a fairly robust conversation about the case. Are there any other learnings, points, pieces that you would want to share with our listeners as far as things that are either successful or areas that you could have improved on the case?
I mean, we tried the case in 8 hours, so I'm not sure we could have been any more efficient. That was a bit of a gulp when we were told we had such a limited amount of time. On top of having limited voir dire, I think Judge Alsup gave me 30 minutes, 20 minutes, something like that.
What I hear in that, though, Craig, is that there are lots of lawyers who feel that they need to put on a big production of a trial in order to get a big verdict. And if you are given guidelines, you can try the case within the guidelines and still get a great outcome.
That's true, yeah. And actually, I've got this case coming up, and we had our final status conference with the judge where this very conversation came up where I said, look, you can limit me all you want on the evidence. Just don't limit me on voir dire. Let me have enough time to, find the right jurors for this case. Give us a couple of days, 3 days for that. And then, you want to hamstring me on how much evidence I put on, that's fine. Because at least I've got the right people hearing the case. And I think that it is true that we, you go through all this discovery, right? And you've turned over every rock. You know where, every little fact is. And there's an inclination that you want to then show how many facts you know about, right? But the jury, that's not helpful for the jury. They're drinking from a fire hose. You need to turn the water down, give them just the things that are most important so that those are the things they're remembering. 8 was a little tight. I think for a civil rights case, 8's pretty tight. But yes, I think the takeaway is you can try your case relatively quickly, and with a good jury, they'll get it.
One thing I thought was really helpful, Craig alluded to informal focus grouping with his colleagues, and I've pitched it to people, and I had thoughts of my own, and I'm sure Brian did as well. And one thing we did, I think it was Craig's suggestion to do what's called a big data focus group. And that way we had, I think it was over 200 people online reviewing important portions of the case, the video, some of the legal facts, some of the law and the facts rather. And it was extremely helpful. I think it surprised us in a lot of ways because, number one, the numbers they were coming back with were a lot higher than we expected. And not only that, but it kind of divided it up based on where the jurors were at on liability. And one thing we learned was that if the jurors thought that it was okay for the cops to initially come up and start talking to the plaintiffs and demand the ID, we were kind of hosed. Either they'd defense the case or the verdict would have been much lower, because then you're just talking about a woman who's like causing problems. Why don't you just show the ID? That was a big concern of ours the entire case. And so what the focus jurors, I think, said was among the ones who thought that none of this was justified. This was all just a racial profiling exercise. They never should have even been approached in the first place. among those jurors, I think it was like a $4 million verdict or something like $3 or $4 million, which was way more than we had ever expected for a case like this. And so what we knew, and Craig can talk about how that played into his trial strategy, but we knew that we needed to really focus on the very beginning of this interaction and how there was no basis for it. All the proffered bases for it were pretextual and BS. And I think that's what we ultimately did. And by the time the jurors were deliberating, they were like, yeah, there was no point in doing this in the first place. This was some racial profiling. And I think that's partly what led to a bigger verdict.
My practice pointer isn't specific to this case, but it bore fruit in this case. And that's, as lawyers, especially young lawyers, you need to invest in your professional relationships. I met Craig 25 years ago when he was a nobody, but I liked him. This guy's smart. And I met Joseph 15 years ago when he was even less of a nobody. And I helped him out just by giving him a couple tidbits. His first trial was against the city attorney's office. And I didn't do anything, but I helped out a young lawyer a little bit before his first trial. And so you maintain those friendships. So by the time we went to trial, we were already friends before we went to trial. But now we've been through the crucible of a jury trial, and we're bonded forever based on that experience. And it's so much fun. Like I said, I've been friends with Craig for a long time, but like to stand next to Craig and Joseph in trial, like, hey, should we strike that juror? Hey, what do you think? What do you think? And it was our collective wisdom that really helped us achieve this great results. And the only time Joseph and I have ever had a disagreement is at the end of a case. We always have an argument over the fees. And the fees argument goes like this. Hey, Joseph, I think you should take a little bit more. And he's like, no, I totally disagree with you, Brian. I think you should take more. So if those are the arguments you're having with your co-counsel, where you're generous with each other and you're focused not on this, squeezing every nickel out of this case, but you're looking at the next case and the next case and maintaining these relationships, and it can cover the gamut. Well, I know this attorney, he's really good at premises liability, or she's really good at assault and battery cases, and maintaining those friendships so that you can refer the cases or co-counsel on the cases. And it just makes, the defense always has the advantage on these cases. They have deeper pockets, less risk. The defense lawyers have less risk because they're getting paid by every month, by the hour. So if you can team up with talented, good people, it levels the playing field, and it's just fun.
Yeah, I echo that. And Miles, I think like when I was at some other firms before Altair happened, and the whole point of for me, the whole point of creating Altair was to be able to partner with other folks. In part, it's selfish. It's because I learned so much by working with other attorneys in every profession, but certainly in the legal profession. We get used to doing things a certain way that feels like it fits us, particularly over time after we've been doing this for a long time. But having the experience of being with somebody who does it a different way or pushes back a little bit on how they do things helps you to kind of constantly reevaluate whether what you're doing is the best way. And I think, and for me, that's exciting. I love being a lawyer. These guys love being lawyers. You love being a lawyer. And part of what makes it exciting, I think, is the learning. And so being able to co-counsel, in my experience, has been one of the best ways for me to learn from other folks. New areas of law, as well as new ways of doing things, new ways of presenting, new ways of deposing people, new ways of doing discovery. We're constantly needing to reinvent ourselves, I think, to do the best for our clients. So I'm a big believer in it.
In a similar vein, I went to an ADC, Association of Defense Counsel conference, where one of the lawyers was saying to me, while we do this, we don't share in the same way that you folks all do. And one of the things I'm very appreciative of is the willingness of the three of you to sit down and talk about, how this came together. Because by you sharing this with others, they will be able to hopefully have some of the same impact that you have had with your verdict. So it's a important piece that I think all of us in this community do is giving back. And Joseph's kind offer to help people vet cases so that we can make an impact.
Thanks for having us on.
As we share pieces, Joseph commented on the big data focus that you did. I'd love to hear a piece of that, who you use and how you do it in order to gather that kind of information.
I think we used Chris Denove, if I'm not mistaken, right? Yeah, we used Chris Denove, who's one of two folks that I regularly use. Damages was definitely our biggest concern in terms of what was the valuation, the proper valuation for the case. But the other big piece that Joseph talked about that concerned me was getting over that hump of the ID, right? Like I think particularly for a lot of white people, they'd be like, just show them your ID, right? Like, what's the big deal? Show them the ID. They'll look at the ID. They'll be like, okay, and you're done, right? And this whole thing lasts 5 minutes instead of 95 minutes. And so I was worried about how that might play out with a jury and getting a sense from people about that. And, we got good information there that definitely could be a problem. And so we had to try to position in such a way where people wouldn't get hung up on that piece, that they'd be kind of incensed is maybe a little too strong, but they'd already be alerted to the inequity and injustice of even asking. And part of our pitch was, well, if you're a white person, you got to ask, sure, you give your ID, but the point is you'd never be asked, right? That's the point, is you'd never get asked. So saying, well, I would just give the ID is a little bit of it's a misdirect, right? You're not going to get asked. And we did, as lawyers, one of our greatest skills can be stealing stuff from other people. So as Brian mentioned, right, we stole from Martin Luther King, we stole from Rosa Parks. Those things can be very fraught with feeling like they're a little too over the top. This case, I felt like we'd earned through the hard work, the whole team and the way we put on the case, we'd sort of earned the right to be able to go there and talk about it, because that's really where we felt like our clients fit in the arc of justice. That's where they fit. But the thing that gave me the most worry was I for anybody who's seen A Time to Kill with, Jake Brigance in his closing argument, right? And it's the story of this young Black girl who is beaten and raped and dragged and left for dead. And he then asked these jurors, almost all white, to now imagine she's white. And we did something similar where we showed the Loggervales in the car, and then we transitioned it to a car full of 3 white women, a mom and her 2 white daughters. Do you think that this thing goes down the same way if these are the people? And there just wasn't, at that point, at least in the trial, I don't think there was any way for any juror to reasonably say, yeah, the cops would have behaved the same way. And so that hopefully took the sting out of the just show your ID thing and got us to the point of, isn't this crazy that in 2019, this sort of thing is still going on just because of the color of somebody's skin. So it was really helpful. I mean, I think they're always helpful, right? We should know about the bad facts. We should know about what people think about damages and what type of people think about damages in what different types of ways, so that we can try to get to the best result for our client. I'm still a big believer in doing in-person focus groups as well. If for no other reason, it's just a great opportunity to get on your feet and give the pitch for the case. But I also think you get something a little bit different too out of having those in-person ones versus the big data. But the big data can really drive the order of your presentation, what you're going to lead with, knowing what you need to diffuse, those sorts of things. That's really helpful.
We also used a jury consultant, Karen Jo Koonan, who passed away shortly after we got this verdict. And she was critical in prepping our clients in their presentation. And our clients followed her advice to the letter. She was dying of cancer while she was helping us. And she was very gratified because she's been on the side of truth and justice for a long time. And it was really thrilling to, call her and share that good news with her before she passed away.
Yeah, Karen Jo is a titan of the jury selection, witness prep industry. I mean, she was at the forefront of that and doing lots of cases, criminal defense cases as well early on. And to have her on this case and have it be, one of the last cases that she worked on was special for her as well as for us. In fact, Joseph had another case that he and I worked on. She was also on that case and had a client that was exact opposite. She's like, this client's unredeemable, but the Loggervale, she's like, these people are amazing. They're going to do great. So it was, yeah. So she got both of those results before she passed away.
Yeah, she will be missed indeed. If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. I will throw it again for any other learnings that you feel we have overlooked in this conversation.
We talked about how they acted at trial, but considering the liability on this, it's not the kind of case that ever should have made it to trial. So that to the extent defense attorneys are watching this, the strategy appeared to be from the beginning: overwhelm, browbeat us. The first phone call with defense counsel, he said, I can't believe this is even a case. This is so clearly a nonsense thing, and just trying to be so dismissive, and hoping that we would just kind of not care and drop it or accept something really low ball. The first settlement offer was insultingly low. I mean, just ridiculous. And that was the tone throughout the case. So I don't know if it was the defense counsel's ego after that. He committed to this position that is a nonsense case and he's going to defense us, that he just couldn't change his view on that. But I mean, looking back, I just don't understand how this wasn't brought into an early settlement and they just said, okay, we get it. We're exposed to fees, even if it's not a huge verdict. And we're going to at least want to account for that. And they just completely missed the ball on that. So I've never done defense work like Brian has. Maybe he can say more about it. But, to the extent they have influence on whether these cases get settled early, take a stab at it. This thing got way out of hand and there was just no going back at a certain point.
To amplify that, we went to a settlement conference with Magistrate Judge Beeler, and she told the defense and the defense adjuster, "You guys you're going to lose on liability." I mean, she didn't predict a multi-million-dollar verdict, but she told them flat out, "This is a case you need to resolve," and they didn't listen. And Judge Beeler, she is I would call her a specialist in police 1983 cases. She gets a vast swath of these cases. So she's seen more than all of us combined. And they didn't listen to her. So, who knows what's going on behind the scenes? Who knows who is the shot caller? But Joseph, and I say this with all love and good intentions, Joseph's OCD on a good day. But when the defense lawyer mistreated him specifically, I was like, I'm just going to hang on for dear life because Joseph left no stone unturned. And Craig talked about our preparation. It was Joseph's preparation. He made us all look good.
No, I don't have anything else to do. That was my life. That's probably why I'm taking a break. I went a little hard.
Harder than normal. I've worked on other cases with Joseph. He's always prepared, but this one, what's the movie line? Now it's personal.
For folks out there who are considering taking a case like this, where there isn't, the physical harm that are more typical in civil rights cases, I talked about comparison. And so I got to spend time on that. And, one of the things that I think resonated with jurors who, again, were already sort of on our team, I think, but helped them when they went back to think about how do we properly compensate these harms for the breadth and the depth of the harm that's been done. The contrast that I think can be helpful for people to use, we came up with 3. So one was, a constitutional violation versus violations of like guidelines or local rules, right? Constitutional violations, those require much more compensation because they're so much more significant and personal in terms of how they affect not only us, but the rest of our community versus, a speeding ticket, right? That's a very different kind of case. So that was one contrast. The second contrast was that when we look at the violation that's occurred, is it a violation where somebody's material goods are affected? Their car was damaged or something like that? Or is it where their safety, security, and privacy is put at risk, where they feel more vulnerable? And certainly when the people who are out there that are supposed to protect you are now instead causing you the harm, that goes to the very issue of safety, security, and privacy. So that was another contrast we used to try and get the jurors to think about, again, what is the appropriate number? And then the other is one that we use frequently in personal injury cases. Is it a lasting harm or is it a minor harm? And here we said, there's no time when the Loggervales are going to see a police officer or go to a Starbucks and they're not going to remember this event. This is going to be with them forever in terms of the way that they see the world. And so that kind of lasting harm requires a different kind of compensation than something that's a one-off. So those are some of the contrasts that, people can use from our case that might be helpful in making sure that their clients are getting full value in their cases when they have some sort of similar fact pattern.
That's excellent. Thank you, Craig. And with that piece of wisdom, I think we are at time. I really want to thank you again, all three of you, for being willing to come on and talk about the verdict and for fighting the good fight. For those of you who are listening, if you like this format modification, we're going to be playing with a few other things. Please let us know at podcast@coopers.law. Likewise, if you have a case that you think would be worth profiling or anyone that you want to have on the show, also please let us know at podcast@coopers.law. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.